Hi everyone, this is attorney Maria Baylor of the law firm of Samuel, Sayward and Baylor in Dedham, Massachusetts, where we focus our practice in the areas of estate planning, elder law, and estate and trust administration. Welcome to this week's edition of Smart Counsel for Lunch. This week I've written a blog on the recent changes to the Massachusetts Homestead Law, which were enacted in November of 2022. As you might know, the Homestead Law protects the equity in your primary residence against claims of creditors who might sue you if you owe them money and get a judgment against you and try and force a sale of your home in order to pay themselves the judgment that you owe them. What the Homestead Law does is give everyone an automatic $125,000 of homestead protection, which means that if you have that much equity in your home and a creditor tries to force a sale of the home, you would get the first $125,000 before the creditor got any money from the sale towards the debt. If you file a Declaration of Homestead with the Registry of Deeds, your homestead protection increases to $500,000. So it's definitely worthwhile for anyone who owns a home in Massachusetts to file a Declaration of Homestead with the Registry of Deeds. It's a very simple form. Your attorney can prepare it for you, but you can also go down to the registry and file one yourself. You just need to know the recording information for your deed. If you're a married couple and you're over 62 years of age, each person can have $500,000 of homestead protection for a total of $1 million. You need to file what's called an elderly declaration of homestead with the Registry of Deeds in that case. So there are different types of homesteads for different situations. If you have your house in a trust, there's a trust homestead that gets filed. So you need to be aware of how your home is owned, but homestead protection can be really important if it comes into play. And sometimes liability or creditor situations can arise, inadvertently. If you're in a car accident and your insurance isn't sufficient or situations like that. So just because your credit cards are paid up to date and you don't have any other creditors is not a reason to think that you don't need a homestead. The changes that my blog this week highlights and that I want to bring to your attention are a little obscure in the sense that they don't apply to everybody, but if they apply to you, bear them in mind. The first change has to do with life estates and remainder interest holders. So if you have transferred your house to a person and retained a life estate, which is sometimes done for long-term care planning, the old Homestead Law only allowed the life estate interest holder to file a declaration of homestead to protect their interest. The new changes that came about in November allow the remainder people or the actual owners of the property to also file homestead protection. So if both the life tenant and the remainder interest holder file homesteads, the entire value of the property will be protected up to the homestead exemptions. The new law also clarifies that owners of co-ops are entitled to homestead protection. And a homestead can be filed which references the notice of lease that applies to your co-op that's typically recorded at the Registry of Deeds. So if you have if you own an interest in the property where someone holds a life estate interest and someone holds a remainder interest, or you own a co-op, I recommend you file a homestead or speak to your estate planning attorney or real estate attorney about how to go about filing a homestead to protect your interest in those types of properties. If you have any other questions about homestead, we're here to help. Please give the office a call or send us an email. As always, thank you for watching, and if you like this video or want to follow our YouTube channel, you can do that below. And we look forward to seeing you again soon. Take care, everyone. Have a great week.